Oftentimes it may not be the number one item on your to-do list, but I would say having a will and having these directives in place is really more about having the peace of mind that your wishes will be carried out in the event that you can't make those active decisions on your own. Welcome back to Invested in You, brought to you by Community First Investment Group. We are here to help you take the next step in your financial journey, no matter where you're starting from. I'm your host, Nate Hastow. Each week, we're here to shed light on investment topics that help and empower you along your financial journey. And over the past few episodes, we've laid the foundation for various topics, including retirement planning, the difference between savings and investing, common pitfalls to avoid, and today we're turning the spotlight on an essential but often overlooked part of your financial strategy: estate planning. Protecting your loved ones, safeguarding your wishes, and preparing for the unexpected are all a part of building a strong, complete financial plan. So what is an estate plan? Well, an estate plan is creating a plan for how your assets, responsibilities, and care are to be handled after you're gone or incapacitated. Estate planning includes more than just a will. It's really important if you value clarity for your family, avoiding court battles, tax efficiency, and many more items. The key components or aspects of an estate plan include a will. Now, oftentimes this is a simple document that's made much more complicated than it actually is, but a will directs who inherits what, the names of the guardians for minor children, and a few other small items. When we talk about who inherits what, this is mostly referring to items or assets, and specifically these are items or assets that don't have beneficiary designations on them. For instance, maybe it is a vehicle that you own that you'd like a niece, nephew, son, daughter, grandchild to have in the event of your passing. Maybe it is a piece of artwork that may not have massive monetary value, but perhaps it was something you painted or was passed down in the family, that you have an artist in the family or even a family friend that would be interested in having this as a way of remembering you. These are things that oftentimes are overlooked, and while again there may not be excessive monetary value applied to each of these individual items, the emotional value that comes along with it, I think, is something that shouldn't be overlooked. The second item could be a trust. A trust is different from a will, even though oftentimes these are looped together. But what a trust does is it controls how and when assets are distributed. It's useful for privacy. The beautiful part of a trust is if assets are transferred in this way, many times you're not going to have to go through the probate courts, which are public record. So it keeps some of the family privacy together. It helps control and create access to resources that minors might not otherwise be able to utilize, especially if you're a parent. This could be very, very important. And if you have family members that have special needs, these are oftentimes applied in special needs planning strategies as well. The third piece is a power of attorney. This appoints someone to handle financial matters if you're unable to do so yourself. Think of this as the license for someone else to drive your finances in the event that you're just unable to do this on your own. The fourth piece is a healthcare directive. This outlines medical wishes if you're incapacitated. So the type of care that you would want to receive if you're interested in being on life-saving support, how long you're interested in being on this support, all those sorts of things can be outlined in a healthcare directive. This also gives someone else the ability to make some of these healthcare decisions on your behalf. So your power of attorney handles the financial side of things. Your healthcare proxy or healthcare directive handles the medical side of things. A letter of intent can be added to this as well. If you find that as you look at your documents together, there is additional information or perspective that you'd like to add for loved ones, this can provide more guidance to heirs or executors on how you would like your wishes carried out. Some real common misconceptions that we see about estate planning. Probably the first pushback is I'm too young. I don't have millions of dollars. I think the reality here is, or I'm too young, well, let's backtrack a little bit. I'm too young I'm not going to pass away anytime soon, is probably the more realistic pushback. Oftentimes, it may not be the number one item on your to-do list, but I would say having a will and having these directives in place is really more about having the peace of mind that your wishes will be carried out in the event that you can't make those active decisions on your own. So the young aspect of things, no one ever really knows when their time is going to be up. So being prepared never hurts. The second pushback is maybe I don't have enough assets that I need a game plan yet. And again, it's not about do I have $1 million, it's about peace of mind that things will be carried out in a way that you feel is appropriate. The third is I already have a will, I don't need all of this other stuff. And I'll tell you, maybe so. There are certain circumstances where having a will is totally fine. I do think that having a power of attorney and healthcare directives at the very least are very appropriate to go along with a will. But what I always tell folks is if you don't know if you have a need or not, consult with an estate planning professional. They know much more about the ins and outs of what is and what isn't a necessity based on the state that you live in and the circumstances that kind of revolve around your life as well. But just in quick summary, it can go very wrong very quickly if there's no direction at all. Having a plan is extremely important. Now, if you don't have a plan, which is very common, what ends up happening, especially here in Indiana, is if you don't have a will in place, the state involves something called intestacy law, which is essentially their best guess of where assets should end up. Now, if you have investment accounts, banking accounts, life insurance policies, let's say you've done everything else besides have an official estate plan document or estate plan packet, the items that you have there in your accounts should have a beneficiary listed, oftentimes a primary and a contingent or multiple contingent beneficiaries. Think of this as initial choice and then backup choices. Those items will go to whomever or whatever organization you've designated on your passing. However, anything else, maybe it's the house, maybe it's the car, maybe it's that painting we talked about earlier, those items, the state will eventually decide where those should end up. So if it's not the natural place that the state comes to, spouses, siblings, children, grandchildren, things are just going to end up willy-nilly. So I think having that in mind, if you do have anything real specific, you don't need to list everything in a will. You don't need to go down to who gets the good silver, right? But at the end of the day, if there's anything that has sentimental value and or some monetary value that we would like to be divided specifically, that's where the estate plan comes into effect. When it comes down to how we coordinate, financial advisors, while they talk a lot about planning, aren't necessarily estate planners. So we do a lot of partnering with estate planning attorneys that really dive into the weeds and customize these plans for folks. But it is a good idea if you are planning on setting up an estate plan to let your advisor know that you're hoping to do this if they haven't brought it up already. And secondly, make a connection between your advisor and the estate planning attorney that you decide to go with. If you're looking for recommendations, oftentimes your advisor has a handful of different offices that they've done work with in the past and typically can tell you if they've had good experiences or not. But that's a good way to get connected to an estate planning attorney if you don't already have one. The beauty here when you can align this game plan together is you can really create a cohesive strategy that has clear communication between both parties that are helping you actually establish the game plan. Review of the plan itself is good to do at least annually. If there are life changes, major life changes, marriages, divorces, passings of spouses, those are good reasons to go through and do a review as well. But ultimately, major life events are a good point to consider that. But oftentimes, if you're partnering with an attorney that's also working with your financial advisor, you can do your annual review of your investment accounts along with your review of your estate plan. So it can really make it kind of a one-stop shop for getting all of your long-term planning taken care of all at once. We do have a Q&A segment today. We had a listener ask, I am in my 30s and I have 2 kids. I have a TOD on my accounts, which is transfer on death. Also POD you might see as well, which is payable on death. Is that enough, or should I include a will and or power of attorney? There are a handful of things that jump out to me from this question. So item number one here is to just get a handle on how old are the kids. If we're talking about an individual in their 30s, there's a good chance these kids are still minors. So I would say there's a really good reason to consider having some sort of an estate plan in place for minor children. The challenge here, and probably one of the number one mistakes I see people make when naming beneficiaries, is they name their children as beneficiaries and their child is like 3. It's going to be quite a while before that child is able to actually legally receive those funds. What can be done here, and again, consult with your estate planning attorney to verify and get all the details of how this can be done. You can create something called a testamentary trust through your estate planning documents if you don't want a full-blown trust that's live and active immediately. Meaning, you can establish the blueprints for a trust in a will, and then you can name that testamentary trust as the beneficiary. Likely as a contingent beneficiary is a better idea to make sure that you have someone who is a live person, probably a spouse, maybe a parent, maybe a sibling, to help handle some stuff up front, but at least as a backup to make sure that the trust is there in the event that the children are still minors and something's happened to the other individual or your spouse as well. That is going to be our episode today. I want to thank you all for joining us on this episode of Invested in You, brought to you by Community First Investment Group. We're here for your now, here for your future. We hope today's conversation helped you take some of the mystery out of estate planning. If so, we'd love to share some new episodes with you coming up here in the future. Be sure to check us out on Facebook, LinkedIn, and if you're ready to start putting your estate plan together or just have a few questions, visit us at cfigadvisors.com to connect with our team. We'll see you on our next episode, which is Business Planning 101. The opinions voiced in this podcast are for general information only and are not intended to provide specific advice or recommendations for any individual. To determine which strategies or investments may be suitable for you, consult the appropriate qualified professional prior to making a decision. Securities and advisory services are offered through LPL Financial, a registered investment advisor and broker-dealer, member FINRA SIPC. Insurance products are offered through LPL or its licensed affiliates. Community First Bank and Community First Investment Group are not registered as a broker-dealer or investment advisor. Registered representatives of LPL offer products and services using Community First Investment Group and may also be employees of Community First Bank. These products and services are being offered through LPL or its affiliates, which are separate entities from and not affiliates of Community First Bank or Community First Investment Group. Securities and insurance offered through LPL or its affiliates are not FDIC insured by FDIC or any other government agency, not bank guaranteed, not bank deposits or obligations, may lose value. There is no assurance that techniques and strategies discussed are suitable for all investors or will yield positive outcomes. The purchase of certain securities may be required to affect some of these strategies. Investments involve risk, include possible loss of principal. Individual tax and legal matters should be discussed with your tax or legal professional. Economic forecasts set forth may not develop as predicted, and there can be no guarantee that strategies promoted will be successful. All performance referenced is historical and is no guarantee of future results. All indices are unmanaged and may not be invested in directly.